to cover whether there's a difference between intent and policy statements and statutes in California. Readers of bills and statutes sometimes come across statements of legislative intent. They usually begin with, "It is the intent of the legislature to do," or you might find some findings and declarations. The legislature finds and declares that, and then the following. On other occasions, you might come across a statement that begins with, "It is the policy of the state that." Now, all of these are expressions of opinion, or they're statements of the desire of the legislature. For example, a recent bill had the following plus section: "It is the policy of this state that all state agencies, boards, and commissions shall utilize their authorities in furtherance of the biodiversity conservation purposes and goals of Executive Order B5418. Now, this is an example where there's an attempt by the legislature to establish a policy of the state, and it's contained in a bill that ultimately becomes a statute. Now, to me, this leads to a question of whether there's a legal distinction or any other sort of significance between intent and policy statements that are used in California statutes. Unfortunately, as you might expect, neither term, intent or policy, is defined in state law. However, based upon the historical usage of these two terms, we have a general idea of how they're used in statutes here in the state of California. In some ways, statements of intent and policy are quite similar. And of course, they're both made by the legislature, even though policy statements generally do not include an introductory statement like intent ones do. There are also some differences between these two statements of opinion. Now, in reviewing statutes and bills, we find that the statements of legislative intent can often be specific in nature, but sometimes they're generalized statements. Policy statements are generally broader because they tend to express goals, but sometimes they too are specific in nature. So they're used for different purposes. Now, the question that I have recently in looking at some legislation from 2023 is, why would the legislature use a policy statement in statute rather than simply imposing a mandate or even providing discretion whether to implement a particular policy? For example, a bill that I came across in the 2023 legislative session was amending Public Resources Code Section 5890 to add, quote, "It is the policy of the state of California that subscribers and potential subscribers of a state video franchise holder should benefit from equal access to video service within the franchise service area, regardless of income level." Now, if this bill were signed into law by the governor, it would establish a statutory policy for the state of California. But in my mind, the policy statement could be changed to an affirmative requirement. For example, a statute could say, "Subscribers and potential subscribers of a state video franchise holder shall benefit from equal access to video service within the franchise service area, regardless of income level." Or we could state, "A state video franchise holder shall provide equal access to video service within the video service area to all subscribers and potential subscribers, regardless of income level." So in either of these two examples that I just made up here, the statute would be imposing an obligation to provide equal access to subscribers rather than making a policy statement in California law. A policy statement is basically an intent statement. It's an expression of an opinion by the legislature. So it doesn't carry the weight and the enforceability of an actual statute. So I pose the question, rather than making a policy statement, why not impose an affirmative obligation or a duty instead?